I don't know why. Test audio 1 2. Okay. So we're live in the right place. Back. Did you guys take a little break? Did you enjoy? But a biscuit. And so weird. All right, so closing arguments about to get started soon. But the way the judge was talking, though, I was thinking it might be over today, but maybe not. Because by the way the judge was talking, he said like they were hoping to get to, I don't know what, jury instructions before the end of the day or something like that. So maybe they'll come on Monday. Unitree go-to robot dog. Quad robotics for adults. There's a robot dog for $4,000. Walkabout Bridge sent it to me. The link. It only has, it's 2.5-star rating though. That's kind of weird. Misinformation. There's nothing in the policy or description from the Unitree that states you have to pay time fee for overseas use. Hidden costs. Nothing you can do about it. You're stuck with the product. Only a 6-month warranty. But a biscuit. Oh yeah, and I meant to say on the last stream if you guys could help out with the like button.
Okay. Does the state
Wouldn't have that many likes.
call any rebuttal witnesses?
No, Your Honor.
All right. You may. Mm-hmm.
Two K likes, really? And a medical recliner listing. Oh, how's your recovery going? You doing all right? What are medical recliners? Like they're just super comfy or something?
Attorney Chase, had you communicated that part?
Ooh, that does really nice. Oh, maybe the medical. I saw something that looks gangster. I don't think that's what you're on. Oh, that sounds nice. Pizza and jammies.
All right. Is the defense ready to proceed with closings? Please.
Defense goes first?
Ladies and gentlemen, first thing I want to do is thank you all for being attentive. I thank you. John thanks you. It was clear that everybody paid especially close attention to some very difficult evidence. I want to thank you all for doing so. Timothy Pouliot's death is tragic, but it is not murder. Let's start again at the beginning of the evening of January 27th, 2023. Now, you heard from a number of witnesses, and you're going to see video, still images. And what I'm going to ask all of you to do, and we talked about this at the beginning of the trial, is use your common sense. It is now time for you to evaluate the evidence. I want you to pay particular attention to the things that people say, but also to the other ways in which people communicate their intentions, their body language, what they say, how they act. And when you're evaluating the images and videos and statements
Sharon, thank you.
of everybody that you've heard from, I want you to take all of that into consideration when you evaluate the evidence of the events on the 27th and the 28th. Now, you've heard from the state's witnesses, one of whom, Olivia, a friend of Abby, somebody who knew John, testified. And what she testified was they were all coming to the GOAT that evening, and eventually John was meeting up with Abby. They were in some kind of a relationship, or they knew each other, or they had previously dated. And John walks up to the group when they're inside the GOAT. And Abby knows John, and John knows Abby. And you see the video. And there's no sound, but you can see that they're clearly familiar with each other. And John walks up at the same moment that Timothy Pouliot, Trenton Nash, and Michael Mendoza are talking to them. And you heard Olivia talk about what the vibe was with Trenton Nash, Michael Mendoza, and Timothy Pouliot. She described that it was a little creepy, or she was uncomfortable, and John walks up. And you also heard that she said that John said something like, "Hey, you gotta leave," to Timothy, or "You gotta get lost." Or maybe he used a derogatory term like, "He's scum." But that's not all that happened at that moment. Review the video. Trenton Nash and Michael Mendoza walk off the screen, leaving Timothy there speaking to John DeLee. John DeLee doesn't have his hands up. John DeLee isn't pushing him away. John DeLee has his hands open. He's opening his body up. He doesn't feel like he's under threat. And at the end of that, back and forth, John offers Timothy Pouliot a handshake. They dap up, and Timothy walks off. And then they continue to socialize and enjoy the evening. But then Olivia tells you something else, that when they go back up to the bar to get additional drinks, they overhear Trenton Nash, Mike Mendoza, and Timothy Pouliot talking about how they're professional fighters and that they're going to knock John out. And it's not that they just overhear this. It's not that they just overhear it. It is said in a way to communicate to those young women in that moment what their intentions are. And so Olivia told you that her and Abby walked down and they warned John, "Look out, those guys are coming for you. They want to knock you out." That's a warning. That's a communication. And then you see more video of John, right? We see John down there at the bottom of the ramp, continuing to have a good time. And then he walks up to the bar. And he has another confrontation with Timothy. And this time it's not so friendly, right? This time there's some harsh language, there's a shove, and a bouncer intervenes. And you heard from Brian Delaney. Now, Brian Delaney said that they were shit-talking each other. And he pulls John aside, and he says to John, "What are you doing? You're huge. You're huge. What are you doing shit-talking this guy?" And when Brian and John part ways, when he sends John back down to the dance floor, what did Brian tell you? They kind of laughed it off. They chuckled it off. as far as John is concerned, his body language, his communication, this is over. This is over. And when Brian goes to talk to Timothy Pouliot, what does Timothy Pouliot say? I'm not worried. I'm an MMA fighter. I do MMA. And then Brian told you he knew what that meant. That's two times that it's been communicated what's going to happen. They're going to try to knock John out. So far, it's only words. It's words. And then we see another video. And that's the video, and we start off with the picture of the dance floor, and you see Trenton Nash, Mike Mendoza in the middle of the dance floor. And they're talking to each other, and they're dapping each other up, and they're talking to their buddies. You see Timothy Pouliot walk down the ramp. And for a brief moment, Timothy Pouliot leans in to Mike Mendoza, and I suggest to you he whispers something in his ear. And then Mike Mendoza turns, takes one or two steps, and throws a haymaker at John DeLee.
Oh.
Then you see them both go down.
Oh, he said he whispered it. Timmy ordered him to do that?
Now we have Officer Smith. Now, Officer Smith testified that he's a detail officer. His job is to be the police presence. His job is to be there to keep the peace. And you have body-worn camera, first-hand, front row seat to that response. And I submit to you that at 22 seconds, you're going to learn everything you need to know about Mike Mendoza. You're going to see Mike Mendoza mouth on that camera, I don't know, or I have no idea. But that's for you to decide. And you're going to see Mike Mendoza's rings. And then as soon as that audio comes on, you're going to see John DeLee's face, freshly cut from being ambushed by Mike Mendoza at the behest of Timothy Pouliot. And we heard from Michael Mendoza. The same Michael Mendoza that claimed to police the evening of that he didn't start anything. He didn't go after anybody, that John was the aggressor. And he did that the night of. From the moment that Mike Mendoza throws a punch and has his first interaction with a police officer, he's minimizing his involvement. He's not telling the truth. And he came in here today and told you, well, as soon as I saw the video, well, yeah, he was confronted with the truth of what he had done and what he set into motion. You hear John saying, "Who punched me? Come fight me." He got punched in the face. And you heard Mr. Mendoza say, well, I threw multiple punches at him. And you see Mr. Mendoza get guided out, and you see Trenton Nash follow him out, and then they just put John DeLee and his friends right out on the same sidewalk. And you see Officer Smith's body-worn camera follow John out. But Officer Smith doesn't walk back out onto that street to make sure that the two combatants aren't put there together. He stops. He turns off his body-worn camera. But just before he does, you hear John say again, "Somebody sucker punched me. Did you see that?" And now John's out on the street, and we have video again of John on the street. And we have video of Trenton Nash and Michael Mendoza going to that car. Now, Mike Mendoza came up to you again and said to you, Trenton Nash never got in the car. It was an ice bank, a snow bank. He couldn't even get in the car. They get in the car, both of them. And they're in the car for a little bit of time. And then Trenton Nash gets out of the car and he starts walking across the street. Now, Trenton Nash came in here and told you, I was going to go smoke a cigarette. But he crosses the street and approaches the people he just saw get into a fight in the bar. He clearly knows who John DeLee is. He's been around John DeLee previously in the evening. He just saw his buddy Michael get into a fight with him. And so he walks up to him. He walks up to him. And of course, John notices this. He sees somebody in a dark coat and a white hat, who he probably saw before earlier in the evening. And that guy's coming towards him. At the same time, he's yelling, "Who punched me?" So he thinks that Trenton Nash is coming towards him because Trenton Nash was involved. And you see a defensive, hurt, upset, amped up John DeLee reach out and shove or punch Trenton Nash. Then you see John DeLee reach out and try to shake his hand. And then there's another punch. And what does Mike Mendoza do, who's sitting in his car watching all of this? He doesn't make a decision to walk away. He doesn't decide that it's none of his business, or he had his shot, he got his shot in, and he already jumped John in the bar. He decides to get out and add a weapon to all of this. And he crosses the street with the pepper spray behind his back, and you can see that on the video from the garage. He crosses the street with the weapon concealed and points it at John. Now, Mr. Mendoza, again, has consistently minimized his involvement in all of this. But you heard Officer Smith talk about what the effects of pepper spray are. It can be blinding, it can make it difficult to breathe, and it can be disabling. And if you watch the video, John notices that Michael Mendoza is standing on the snowbank with the pepper spray in his hand, pointing at him. And at this point, seeing pepper spray pointed at him, he pulls a gun out of his waistband. And he drops it because he's not expecting to have to defend himself from somebody with a weapon. But he picks it up and you see him rack the slide. Why is that important? John didn't go into the goat that night with a loaded firearm. But now he's under threat. He has two people who have approached him outside of the goat after he was jumped inside of the goat. Doesn't know who these people are. He doesn't know what their problem with him is. All he knows is that they keep coming at him. And now they have a weapon that can leave him disabled, unable to protect himself. But he doesn't point the gun at Michael Mendoza. He pulls the gun out, he loads it, and it remains at his side. And it's at this point that you've heard multiple witnesses tell you that they begin to push John up the street. That's credible and that's normal. You can watch that video for yourself and make your own decision. What's most important is John moves in that direction. And Matt Soldano told you why. That is where safety is. The car is at the Market Basket parking lot down that alleyway. They need to get out of there. Matt Soldano knows that, and that's what they tried to do. But Mike Mendoza and Trenton Nash have no interest in seeing them get to that car. Mike Mendoza's car is in the opposite direction. It's across the street from the goat. Trenton Nash's car is either 10 or 15 minutes away, or it's in the Bank of America parking lot. It depends on who you want to believe, Mike Mendoza or Trenton Nash. But they're not moving towards their car. Look at the body language of everybody in that video. Mike Mendoza is lifting a middle finger into the air and screaming at John DeLee and his friends as he walks in the same direction that they do, following them up Old Granite Street. John DeLee and Matt Soldano are trying to get back to their car, and these two people who have attacked John twice are following them. Where's Timothy Pouliot? There's video of Timothy leaving the GOAT and walking in the opposite direction for a short period of time down Old Granite Street, away from the Soho. But he stops. He turns around. He looks to see where Mike Mendoza and Trenton Nash are and where John DeLee is, and he turns around and he follows. You heard from Brendan Enright. Brendan Enright doesn't know any of these people. He doesn't know John DeLee. He doesn't know Timothy Pouliot. He doesn't know Mike Mendoza. He doesn't know Trenton Nash. He doesn't know Matt Soldano. He's just on the street. And what does he hear? Hey, pussy, this is New Hampshire. We all have guns. And then he turns as Timothy Pouliot walks next to him, and he warns Timothy, that guy's got a gun. You don't want any of that. But Timothy doesn't stop. Michael Mendoza yells out, he's got a gun, he's got a gun. Nobody stops following John DeLee and John DeLee's friends. They keep going. Wherever you think they might have gone, or wherever they think they might have gone, it's on video. It's on video every step of the way, with the brief exception of that blind spot right outside of the Soho. They go from the GOAT, and in the case of Timothy Pouliot, from further down, all the way up the street to the corner of that alleyway. Nobody stops, nobody goes back to their car, nobody thinks better of it. As John is making his way back to his car with his friends, 3 people follow him. Yelling and screaming, he's got a gun. You saw video of Abby Elliott running up the street and trying to stop Timothy Pouliot. That doesn't work. Now, you're going to see video again of the Soho. And we see the alleyway, and we see the area in front of that restaurant. And we see the pursuit. And you see the body language. Chandler Gage, who was identified on video by the detective, with Matt Soldano, who identified himself and was identified by the detective, waving at anybody who will look at them and listen. Stop, get back, stay away. And you heard Matt Soldano say that when he heard that they were being followed, when he realized that they were being followed, he told John to not go down the alleyway. Why? Because nothing good happens in a dark alleyway. This isn't about retribution. It's about the relentlessness of the 3 people that pursued John DeLee up the street that evening. Michael Mendoza is armed with pepper spray and rings on his hands that he admits to having, that you can see for yourself. John knows that. He saw the pepper spray. These people intend to do him harm. It's not one person. It's not two people. It's three people. At some point, the decision is made to not go down that alleyway. He turns his back and he's in danger. He makes a choice to stay in the light, to stay where there are people. People in light means safety. That's your common sense. And so he stands where he is. And he doesn't point a gun at anybody. He doesn't threaten anybody. He stands there with his friends, hoping that this is going to calm down. But it doesn't. And you don't see John throw punches or shoves or point a weapon or do anything like that in any of those videos. And then Timothy Pouliot, the MMA fighter, and Mike Mendoza, who has already threatened John with a weapon, and Trenton Nash are now arrayed within arm's length of John DeLee at the end of the street across from the alleyway. And then you heard Matt Saldano tell you that he got searched for a weapon and asked, do you have a gun? And you heard what that made Matt feel like. He knew why they were asking him that question. And he puts his hands up and he walks away. In that moment, John is alone. 3-on-1. Against three people who have not only told him they want to harm him, who have not only communicated in very clear terms that they are capable of harming him, they have already tried twice. He's at a road. But he doesn't point his gun at anybody. He stands there, and he's staring right at Mike Mendoza. And then Timothy Pouliot throws that punch. The professional fighter, the MMA fighter. And you see John take a step back and fire 8 or 9 straight shots. It's on video. You get to see that. Now, Ayla came and told you that she heard different. She said, well, no, I saw 4 shots and then shots while Timothy was on the ground. That's not what the physical evidence shows you and tells you. You see the cell phone video, you see the bullets hitting the ground, and then you see Timothy fall backwards. And you see him twist to the left and to the right, but he never stops facing John. As soon as the threat of Timothy attacking John is gone, John stops. The police seized his firearm. You watched Officer Smith respond. He's the closest officer at all times. He's the closest in the bar. He's the closest on the street. He makes it up there in minutes. John is there. He has not run away. He has not left the scene. He has stayed. He immediately places his firearm on the ground, and the officer immediately stands over it to secure it. A detective comes and collects that firearm. They secure it. They render it safe. And you've heard testimony from the state's expert and the state's own detective that there were 5 rounds left. John didn't start shooting and keep shooting. John shot until the threat was gone. He stopped when there were no longer 3 people arrayed in front of him, intending to do him harm. He stopped when Timothy hit the ground. He didn't stand over Timothy. He stepped away into the alleyway. The police came and he surrendered. Your job is a difficult one. In the moment that John stood there on the street, nowhere else to go, arrayed with 3 people in front of him that he knows mean to do him harm and are capable of it. He believes they're capable of it because it's been communicated to him. They're professionals. They're willing to throw a punch. They're willing to throw a sucker punch. They're willing to pursue him up the street that all of you walked. That's not a short distance. That's not one building over to the next one. John tried to walk away. He was going towards his car. Timothy Pouliot, Mike Mendoza, and Trenton Nash followed him. There is no other definition of what they did. And while they're marching up the street, wagging their fingers, pointing at John and his friends, waving them off. So you may hear that people say, oh, they were talking back and forth. They were being combative. They were being combative as they were walking away. They were being combative as they were trying to get back to their car while they're being followed. John had to believe that he needed to use force to defend himself. Lethal force to defend himself. That he was at risk of serious bodily injury or death. A professional MMA fighter had expressed to him in no uncertain terms that he wanted to knock him out before the end of the night. And he had help. And they know that John is armed. In the moment, if you think that you're going to be knocked out and you have a gun and they know it, what happens next?
They take the gun.
In the moment, what do you think is going to happen next?
Don't take it. Take the gun.
His life was in danger. The judge is going to define for you what that is. Serious bodily injury or death. Every step that every person on that street took towards the Soho in pursuit of John DeLee was a choice. Everything that they communicated with their body language and the things that they said was a choice. And it started in that bar when Timothy Pouliot told Mike Mendoza to throw that punch. And it's tragic it ended the way that it did. But it is not murder. It was self-defense. And in that moment, when he's going to get struck in the head for the second time, he has no choice. He has to act. He has to defend himself. I submit to you that when you watch these videos, when you listen to what people have said, when you decide what everybody's intent was, it will be clear. It will be clear that John acted in self-defense and that his acts were reasonable based upon everything that had been communicated to him that evening. It is tragic, but it is not murder. Thank you.
What y'all think? Compelling? Or just, whatever? What y'all think? Y'all thought it was compelling? That was alright. Let's see what the state says. See what they bring.
Come get your boy. He's bleeding out. That's the extent of the remorse that he had.
Point.
There was no fear. There was no terror, and there was absolutely no reason for the defendant to be in fear. He was bigger. He was madder. and he had a loaded Glock stuffed down his pants. This case is about the defendant's anger, the evolution of anger. You watched the videos. You saw it. You'll be able to see it. I agree with the defense on little, and we're going to talk about some of the things you've been told. But I agree, you should look at the body language. You should watch the reactions. You should watch how they're talking, how they're moving, how they're communicating. Because when you see that, what you're going to see is that this man was a bully. He was a tough guy picking on the little guy. That's who he was. Timmy had been pushed around. Yeah, he went up there and he wanted to fight. He wasn't afraid of the bully. And frankly, that just pissed the bully off that much more. This isn't self-defense. This isn't necessity. This isn't from fear. This is anger. This is absolutely retribution. This right here, the fatal shots to the back as he fell to the ground and bounced off the cold pavement, this is an execution. Absolutely nothing less. We talked about this in voir dire. Necessity is required. Actual and reasonable fear of the threat of imminent deadly force. That's not this. This is not that. You heard in this moment what this was. Mr. Saldana, and we are going to talk about his credibility issues. But what we do know is that he was trying everything he could to get the defendant to stop, to calm down, to walk away, to leave, because this wasn't necessary. Before we go any further, we need to talk about where we're actually at with this case. Not theories, not stories, not movie plot lines about people tactically maneuvering and everything else we heard at the beginning of this case. We need to talk about the facts and the law. We start this case, when you walk back in the jury room, we start this case at this point. The defendant pulled out a gun and he shot Timothy to death. That's not up for debate. The defendant knowingly caused the death of Timothy Pouliot. How do we know that he did it? You saw it. How do we know? Ladies and gentlemen, we all know that if at near point blank, you pull out a gun and you dump 8 bullets into them, into their back as they fall to the ground, it's probably going to cause their death. That's the starting point. Nothing less. You're going to be instructed to consider manslaughter, provocation manslaughter, recklessness. We'll talk about the law, but you know what recklessness is. You know what reckless driving is. This wasn't reckless. This isn't reckless. Boom, 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 boom. Continuing all the way to the ground. That's murder. That is knowingly causing his death. But John was in fear. Absolute fear. At least that's what we've heard. When was that exactly? When did we get any evidence that he was in fear? Did you see any videos that he was in fear? And let's talk about the points a little bit where maybe you would have seen fear. There wasn't fear at the bar. Remember? He looked over, he saw Abby. And why would there be? A foot taller, 200 pounds bigger. 200 pounds. And actually, it's more than that. You heard the stipulation. 350 pounds. 230 pounds. More than an average person, an average male in size on him. He towered over him. Feel free to watch this interaction too. I encourage you. And also watch the interaction when the defendant's ex-girlfriend pushes Timmy on the way out of the bar. Because what you'll notice is Timmy's reaction to both. I don't know what he's saying. It's your job to look at his body language. But yeah, Timmy brushed off the scum comment. He moved along. And another reason, and we already talked about this, the defendant was there with his friends. You saw Gage walk up behind the defendant when he confronted him at the bar. He had his buddies backing him up. But this is old reliable. This is the buddy that will never let you down. One squeeze, what was it, 6 pounds? 6 pounds of pressure. That's the difference between life and death. He had no problem pulling that out and using it. I lost count, frankly, of how many times you heard pro fighter. You've heard it a lot. Pro fighter, pro fighter, pro fighter, pro fighter, pro fighter, pro fighter. Okay. This is what the defendant did with that information. Where was the fear of the pro fighter? Where is there evidence of fear of the pro fighter? Because what you saw, and again, I encourage you, just like the defense attorney, go back and watch the video. Watch what happens when Abby comes back and tells the defendant. Watch the laughter. Watch them laugh. And of course they're laughing. I think Brian Delaney summed it up perfectly, didn't he? Remember what he said? Little dog barking at the big dog? Watch their reactions. Well, watch the defendant. Watch where he looks after that. Watch where he stares. Even amid conversation as they're having fun. Watch where he's looking. He's looking up here. Because this guy, this little scum, he dared to tell the defendant's ex-girlfriend that he thought he could hit him, knock him out. Who the hell does he think he is? I'll show him what's up. So he went up to the bar. Let's go, pro fighter. Let's go outside. Wait a minute. How fearful are you of someone if you're going to ask them to go outside? Pretty scared of that pro fighter, wasn't he? Let's go outside, buddy. Because what does he know? You got 200 pounds, a gun, and some buddies behind him. And when Timmy says no, he pushes him. I'm not telling you that that's the crime of the century, but make no mistake, counsel just told you that the first physical thing, he skipped over this. This is the first assault. This is the first physical aggression. This is that evolution of anger that we see. All right? It starts with walking up. You don't talk to my girl. Who are you, scum? Or you're going to tell my girl that you think you can take me? Hell no. Watch that video, and we'll see a short clip of it. We're seeing it. We're seeing that anger, the deep-seated anger. We've heard a lot about the punch heard around the world. And we're going to talk more about that punch, the claims you were told on Tuesday that you would see about that punch. But there is absolutely, unequivocally, no doubt that the defendant wasn't scared after the punch. We know that. You heard it, and I know sometimes it probably sounded monotonous because you heard us asking anyone that was up there, did he ever say he was scared? Did he ever say he was in fear? Did he ever ask for help? Did he ever say that anyone wanted to fight him? No, he didn't. He wasn't in fear after this. He was mad. You heard what he's screaming. He's swearing, he's challenging, he's demanding. What are we seeing? The next tick of anger. It's that evolution. It's spinning up. He's becoming more angry. More angry, not fearful. What fear? And we know he wasn't afraid outside, don't we? Because what does he do when he goes outside? You've had to listen to a lot of curse words and inappropriate language. But that's because those are the words he chose. You heard Mr. Enright testify. Where you at, pussy bitch? And you can hear it. You can hear it on the recording. Then it's out here. What's up? Who punched me? What's up? Who punched me? Where you at? Screaming. Fear? What fear? What fear? And Mr. Nash, all 130 pounds of Mr. Nash that we heard, you all get to judge Mr. Nash's credibility. You all got to see him walk into this courtroom. And you have heard the claims about this interaction. But we saw the interaction, okay? You saw what happened when Mr. Nash walked up there. Mr. Nash doesn't push him, doesn't touch him. No, we don't know what was said. We have testimony about what was said. But what we can see with our own eyes, unequivocally, defense counsel may characterize it as a push or a punch. Ladies and gentlemen, that is a punch. Mr. Nash told you about that punch, and it was a second punch. But that actually gives us some pause, and we'll talk a little bit about this. So now we have the first assault, the defendant. We have the second assault, the defendant. We have the third assault from the defendant. 2 punches. No death. No serious bodily injury. Outweighed Mr. Nash by 200 pounds. No death. No serious bodily injury. Because it's a punch, ladies and gentlemen. And there was no fear of that punch, of Mr. Nash, of any of it. Just like there was no fear of the pepper spray that you've heard all about. It is lawful, and you will see this in the jury instructions. It is lawful to use non-deadly force to stop non-deadly force. What does that mean? That means somebody is using non-deadly force, like punching somebody. It is lawful to use a less lethal, non-deadly force, like pepper spray, to stop. Okay? That's what Mr. Mendoza did. He didn't even spray him. He walked up and told him to stop. And if you're wondering, well, what was his other motive? If he wanted to incapacitate the defendant with this pepper spray, here's his time. It's here. It's before the defendant has a gun. Mr. Mendoza doesn't know about the defendant's buddy, Mr. Block. He doesn't know about that yet. He's going to disable and take this guy out. It's right here. But Mr. Mendoza doesn't do that. And the defendant has absolutely no fear. No fear, and you know that. You heard the walked up the street. Is this walking, or is this being shoved? Mr. Saldano explained that to you, that they had to push him up the street because he's trying to get back to Mendoza. He's not afraid of that pepper spray, and why would he? He's got the equalizer in his head. He's not afraid of pepper spray. He keeps jawing the whole way up the street. That's not fear, that's anger. Watch the video. If you have questions about what happened in this time frame when the defendant walked down that alley, watch the video. Pull them up full size and watch it. Watch where everyone else is. All the way across the street. They broke off. They went the other way. There was no fear in Soho. This isn't fear. This isn't the face of fear. This is the face of a tough guy looking for a fight. But now it's amped up. We're seeing it again, right? This is anger, ladies and gentlemen. This isn't fear. And Mr. Saldano admitted the defendant ends up going around him. And you'll see the video of Mr. Saldano pointing for him to get out in the alley. Again, we'll talk about Mr. Saldano's credibility issues, about the whole he told him to stop. A little confusing since, 30, 20 seconds after Mr. DeLee stops, Mr. Saldano was pointing for him like this to get out in the alley. I think we know what really happened during this interaction because we have it on video. But what we definitely don't see is fear. Anger, absolutely. Fear, none. Anger did this. It wasn't fear that made the defendant target Timmy and Timmy alone. You've been led to believe that the defendant feared Mr. Mendoza because he had rings on and because he had pepper spray. Every single bullet, 8 out of 9 bullets, hit Timmy, the smallest guy in the group, but the guy that had talked to his girlfriend, the guy that said he could knock him out, and the guy that stood up to him and punched him. Not condoning it, neither should you. But he shot Timmy out of anger, not because he feared him. Watch the video. We explained to you folks how, Detective Lovejoy explained to you folks how to use that VLC player and how you can go frame by frame. If you have a question about what the defendant was doing, take your time with it. But what you won't see is any deviation from Timmy. He followed him all the way down. Execution style, not self-defense style. He wasn't spraying it around saying, "Get back." It's like this. That's how it happened. Because it wasn't about fear. Now, frankly, that should be the end of this closing. That should be the end of me talking, and you should have this case. But there's been some misstatements, there's been some mischaracterizations, and we need to correct some of that. And we need to talk through some of that. The defendant didn't need to call any witness. That was his right. But he did call witnesses. So you need to judge what you've heard and seen just as critically as you would the state. Let's start with Mr. Enright. Mr. Enright was a bystander. He didn't know anyone. We agree. He didn't have a dog in a fight. He was courteous. He was polite. He answered questions. He swore to tell the truth. But what we saw was Mr. Enright was not accurate on details that we know, on details that you don't have to speculate about. And we talked about this in voir dire, right? The difference between lying and just getting something wrong. All right, and we all agree that there's a difference. Sometimes getting things wrong just happens. We all saw this, right? Mr. Enright explained that they came out of the goat, and there was a large group following him, harassing him. Some girls were spitting at him, swinging at him. And Mr. Enright said that after that happened, and after the defendant pulled out the gun, that the group ran straight across to this end, straight across to right here. And that's where they stayed. If you remember, I asked them, did they go up the street? No. Did they go down the street? No. They went straight across to where you marked the X. Yes. Okay. And that's where you heard them make that statement? Yes. Okay. So what we know, now I want you to think about the time. In this time frame, we have lots of people yelling about guns, right? We have Abby, the defendant's ex-girlfriend, screaming at the defendant to put the gun down. Remember, this is when the gun's out. This is after the pepper spray incident. Abby is screaming, "Put the gun away, put the gun away." Mr. Mendoza's running up the street, screaming, "He's got a gun, he's got a gun." Did Mr. Enright confuse something? Maybe. But if somebody said that, and it was over here, it wasn't Mr. Mendoza, it wasn't Mr. Nash, and it wasn't Mr. Pouliot. And also, how does that help you? How does that help us figure out what was going on in the defendant's mind at that time frame? There is absolutely no evidence that the defendant heard that statement. None. There's not even evidence that anyone near the defendant heard that. Mr. Saldano certainly didn't hear that. No one else heard that. So you're being asked to decide this case based on speculation. Speculation that it was said, speculation on who said it, speculation on who heard it, speculation on how that affected them, speculation on why that would cause him to shoot him 8 times. That's not how we decide cases. That is not how we judge someone's guilt or innocence. There is absolutely no evidence that that played a role in any of this. what is corroborated about what Mr. Enright said? What do we know is corroborated? We know that this was back and forth. Mr. Enright doesn't have a dog in this fight. He doesn't know Timmy. He doesn't know Mr. Nash. He doesn't know Mr. Mendoza. He doesn't know the defendant. He doesn't know his friends. But we know it was back and forth, and he said it was. No one was trying to back down. No one was trying to leave. No one was trying to ask for help. It was a back and forth. Defense in the opening tried to lead you to believe that this was a coordinated attack and the defendant was just scared. Is that what you saw? Is that what anyone described happening? No. So let's talk about a couple other things that you've been asked to believe. You've been asked to believe that Abigail Elliott Ward was a hero. That she was trying to stop Timmy from running up the street. Really? We have the video. That's not a question. Miss Elliott Orr ran up the street and pushed him. And sorry, I don't mean the first time she shouldered him in the bar and then dressed him down yelling at him. I mean this time on the street when she broke free of her friends and sprinted all the way up there and pushed him as physically hard as she could. That's what I mean, that time. The evidence is a little bit different than what you've been told. Mr. Saldano. Mr. Saldano came in this courtroom and he told you some things. You heard some inconsistencies, and I'm not going to go through each one of them. But we have to at least talk about why you should give his testimony very little weight. If he said something and it's not on video, you should be very suspicious about it. We obviously know about his inherent bias. Friends from middle school, typical stuff. This is his buddy. This is the guy, they're tight. Now we, again, talked about the difference between lying and making a mistake. Lie, lied, lying are very, very, very sharp words. Mr. Saldano, though, took this stand as a liar. He lied to the police. And that may not sound like a big deal, but let's put this in perspective. Mr. Saldano, according to him, is terrified. More terrified than he'd ever been. So scared that he ran into Soho Bistro. Ran in. Now remember what he was afraid of. He is afraid that these three scary men are going to do something to John. And he is terrified. So he runs into Soho. But while Timmy is lying in his pool of blood on that cold pavement, Mr. Saldano is in Soho lying to the police about what he saw and what he heard. And the reason he was lying was because this was his buddy. He knew what happened out there. He knew how mad the defendant was. He had just tried to get him to leave. He lied to the police because he didn't want to jam him up. Mr. Mendoza and Mr. Nash were in the thick of it. You've been led to believe that they're the boogeymen. They spoke to police. They stayed. Mr. Saldano, I didn't see anything. No, didn't hear anything. Really? You didn't see anything that you thought might be relevant to a murder investigation? You're going to stand there and lie to a uniformed police officer who's investigating the murder of a man who's bleeding out in the street in that very moment? And I'm not going to go through, frankly, every single inconsistency. But there is certainly one that stood out. I told John to stop. You told John to stop. The day after, the morning after he has lied to police, he sits down with the defendant's investigator and he tells her things. Details, super important, right? Yeah, absolutely. Okay. Left that out of the report, didn't he? Then you heard he testified under oath before. On this issue, he was handed that very report, and he was asked, is this accurate? Is this complete? Is there anything you need to add? Is there anything you want to add? Anything you forgot? Nope, that's fully accurate. He was handed a business card so that he had an opportunity, if he remembered something differently, to call. But then he comes in here and tells you, John, stop because I told him to stop. Does this look like telling John to stop? This is seconds after the defendant turns around in that cell. 30 seconds, 20 seconds, I can't remember right now. You're more than welcome to watch it. Mr. Saldano didn't tell the defendant to stop. He was telling the defendant to go, which is what he was doing the entire time. And don't forget, Mr. Saldano did admit no one followed them down that alley. He admitted that when he apparently told him to stop, that Mr. Mendoza and Mr. Nash were across the street. How much sense does that make? You have to ask yourself, is there any reason to believe that Mr. Saldano didn't come up here and lie to your faces just like he did to that police officer that night? Again, if he told you something and it's not corroborated by video, you may want to look at the video. And let's talk about another claim you've heard. We have heard a lot about the punch. A lot. In the opening, you were told, direct punch. That first punch, direct punch, caused the injury. That's what you heard. That's what you've heard this whole trial. He direct punch, direct contact. Okay, let's watch it. There's Mr. Mendoza. Ooh, let's watch it again. And again. Now notice something about what side of the face he's swinging towards and what side of his body that punch goes to. Goes to the opposite side of where that cut is. But John's face hits this when he pulls Mendoza to the ground in the fight. Now why do I tell you this? Why does it matter that there was a strike, swing and a miss? It matters because we don't mischaracterize. You need to judge this case based on the facts and the law. And the fact is that Mr. Mendoza missed. It doesn't matter. The state concedes. He went over there looking for a fight with Mr. DeLee, and he got one. And Mr. DeLee was kicked out. It doesn't change any of the events that happened after. But what it must change for you is think about the bill of goods you've been sold, what you've been told. You were told direct contact, direct punch. Mr. Mendoza's ringed up hand took him out. I think the quote was, darn near knocked him out. And then he had this fear of those rings. Remember? You kept hearing about the rings. What evidence is there that that the defendant knew about the rings? How did that affect his state of mind? It couldn't have, because he didn't connect. Again, and we talked about this very briefly, the claim that Trenton Nash walked right up and, quote, got in the defendant's face, got in John's face. That's what you were told, got in his face, was continuing the attack. That's what you were told. So let's see. There's Mr. Nash walking up smoking a cigarette. Mr. Nash getting directly in his face, continuing the attack, right? Only after he was punched by a guy 6'6", 350 pounds, he didn't so much as raise a hand. Didn't push him, didn't hit him, didn't kick him, nothing. Now, it's your job to judge credibility, character, all of that. It's not mine. You saw Trenton Nash come in here and testify. You heard his demeanor. You heard how he talks. You got a kind of feel for how he thinks about life and how he carries himself. Mr. Nash wasn't a threat to the defendant, and the defendant knew it. You heard a lot of questions about, did the defendant just tell you to go? And you heard that in the opening, right? The defendant told him to go away. Just go away, sir. I don't want anything to do with you. Okay, well, let's check the video. This is Mr. Nash coming over. Easily confused. I'll smash that fucking face! A little bit different than just go away. Get away. Get out of here. No. It's a little bit different because this is what actually happened. Just like you heard, I think we just heard that the defendant was out of road. That's what we heard at the moment of Soho. The defendant was out of road. You went out there. You saw it. Out of road? Out of which road? He could have walked behind him 20 feet and gotten to the, busiest road in New Hampshire? He could have walked into Soho. Because remember what Mr. Soldano said he did when he was in fear? He ran into Soho. Fancy that. A business is open, and if you're fearful, you can walk in there for safety. Something that just didn't happen. I'm not going to spend a lot of time on going through the series of events, but given the back and forth, I'm going to spend a couple minutes just going through what happened, what the evidence actually shows happened, and then we'll talk about the law. Oh, my apologies. I forgot about some of the other claims that you heard. The planned attack, the tactical maneuvers, the lookouts, the hiding. That's what you were told on Tuesday. How much of that did you see? How much planning and coordination happened? And when did that happen? When did Timmy, 007 Timmy, have time to coordinate this attack? And what tactical plan did he devise where instead of taking Mr. DeLee and spraying him when he's punching Mr. Nash, did he think it was a good idea to wait until he had brandished a gun and walked up to him in the middle of the street? There is a difference between what is factual and a characterization. And I encourage you to follow the facts and the law. This is where it started. This is what started it that night. The defendant up here and Timmy talking with his friends. If you watch the video, you'll actually see Mr. DeLee come up here first, talk to a couple of the friends, and then goes down. He walks up. This is where it's beginning. This is the moment where he's telling Abby, what are you doing talking to these scum? You know what happens here. This is where that tough-talking Mr. Mendoza and Timmy are talking tough to the girls they've been hitting on all night. The ones that they were just embarrassed in front of, called scum. And they say, I'm a pro fighter, I'll knock him off. That's what they said. And Abby went and told the defendant. I already said this. If you're interested in the actual reactions to that, watch the video. You know what actually happens. This is what happens. The challenge to fight. Remember this? The big dog showing the little dog who's boss, pushing him down the bar like he's a sheet of paper. And then we know what happens. Mr. Mendoza comes down. I'm not going to go through that video again. You saw the swing. You saw the scuffle.
You know what? Hey, God asked us in that line.
You were told during closing that the moment before this, when the defendant had pushed Timmy and walked down to the bottom of the ramp, how happy John was. How he was just dancing and having a good time. Right? That's what you were told. Yeah, of course he was. He did the typical bully thing. He had just walked up, flaunted his size, flaunted his strength, put this little scum in his place and slid him down the bar. And watch who's watching when he's doing that. And you will see Abby looking up there, watching, going like this. Ooh. Stuff like this. He was happy because he just played Mr. Tough Guy. You know what happens here? We showed you. He comes out of the bar. He goes up the street. You heard Olivia describing the anger that everyone was trying to calm him down, but John wasn't having it. He wanted to finish this fight. Who dared to hit John DeLee? Who dared to do that? In front of his girl? Think about how mad he was that Timmy was talking to his girl. How mad he was when Timmy simply said something to his girl. You're going to punch John DeLee in front of Abby? And not get away with it? And he wasn't calming down for anyone. You know what happens here. You know the pepper spray comes out. You know the defendant's tone and demeanor. You heard characterizations of it, but this is what was actually taking place. You also heard a lot of discussion about where everyone went, and it's all captured. I know it's not great quality, but from the parking garage that captures from the far right to the far left, you can watch all the movement. You can watch that and then the Soho video, and you can figure out where everybody is. But this is where everyone goes. The red line is John and his friends. The blue line is Mr. Mendoza and Mr. Nash. And whether you like Mr. Mendoza, whether you think he's a bad guy, it happened just like that. That's what happened. You can watch it on the video. That's where the people went. No one was following them down the alleyway. He could have kept going. What was it? They were going to their home, the safety of their car, right up here. On his way. The other guys are going the other way. But instead, you saw this. You saw this happen. You saw the defendant turn around. You saw him throwing his hands. You saw him pulling that gun out and hollering over to those people. Apparently in so much fear. He was so scared of these three guys, he thought it would be a good idea to be challenging them to come over. And as Mr. Saldana was telling him to leave, nah, I'm going for these guys. There is a gap between these two cameras. Call it the arena. He was going into that arena. They were out there. He was stepping into the arena because he wanted to fight, not because he was scared. There's no evidence of that. And what follows this? What follows the defendant entering into that arena after he has demanded to fight? After he has pushed people and hit people and used derogatory names and swore at people, had to be pushed up the street? What followed that is this.
These guys are awesome.
Hey, get back here, back here. Think about just how ready he was to use that gun. Now, you know he had pulled it out a couple times. How he had racked that gun. You can watch him on the Soho clip pulling out that gun. Think about how ready he was to use that gun to be able to pull it out that quickly, target Timmy, and put bullets in him all the way to the ground. To the point the detectives told you, and you saw, bullets ricocheting off the pavement. That's intentional, ladies and gentlemen. That is anger. That is not fear. This wasn't a spray and pray. Get it back! It wasn't any of that. It's this, all the way to the ground. Execution. There's a question about his state of mind. The question about what was going on. You heard witnesses describe his state of mind. And defense is right. You did get a glimpse into that in that minute or so after the police got there. You heard what happened, and maybe you didn't pick up on it. So let's think and let's listen about how the defendant is describing his state of mind in this moment.
Old Granite Street.
Three fucking Manchester fucking scrubs, dude. You stood in that spot. You stood in that exact spot on the view. And we asked you to turn around and to look around. He is standing 15 feet from Timmy's dead or dying body. His body filling up with blood because bullets that he shot ripped through his organs and his heart. And he is standing there calling him a Manchester fucking scrub. A lot of fear, isn't there? No anger, just fear. He was terrified. That is not fear. That's the bully. That's the anger. That, ladies and gentlemen, is how you know, when you go back there, that he knew what he was doing and that he caused the death of Timothy Pouliot. There is a lot of charges for you to consider. This is what the defendant did. But we've got to talk about the law on fear, because you have been told John feared for his life. Okay. Let's start first with what's not self-defense. You can't use deadly force against the threat of non-deadly force. You can't kill somebody who is using non-deadly force against you. Excuse me. Street justice, and we talked about this in voir dire, just because somebody punches you, just as somebody pisses you off, just because they wronged you, doesn't mean you get to execute them. In retribution, those Manchester fucking scrubs, that's not self-defense. Deadly force is defined as this. Any assault that someone commits with the purpose of causing or which he knows to create not just death or serious bodily injury, substantial risk. So not just a chance that it could do it. Not just a one-off, a substantial risk. Now you may be wondering, well, how do we know that that's not a risk? Did Trenton Nash come in here and testify? Was he still walking, talking, breathing? Did you hear any evidence about any serious bodily injury? This man, who you saw stand up when witnesses went to identify him and towered over everyone, punched scrawny Trenton Nash in the face, not once, but twice. No serious bodily injury, no death. Because that's not deadly force. That's a fight. Again, Mr. Mendoza has a different idea. He's from a different background, from the street. For him, a fight is a fight. All right? That's what this was. That's not deadly force. fear. We've talked about this. It's not just fear. It's actual. It's an actual belief that you are faced with the imminent use of deadly force. That deadly force is right about to come upon you. You have to actually believe it, and it has to be reasonable. We already talked extensively. There was no actual fear. The defendant wasn't afraid of anything. And if he was afraid of anything, it wasn't reasonable. But again, we don't get here because we know there was no fear here. Excessive. This is common sense. We all know this. We agree. Use your common sense. Ladies and gentlemen, you can't use excessive force in self-defense. Only a reasonable amount of force. All right? This case, what happened here? In this case, excessiveness was the difference between life and death. You heard the medical examiner describe that for you. If the defendant had stopped shooting, if when Timmy goes like this and starts falling to the ground, that was the end. That's when the threat was over. So even if you believe he was justified in pulling that trigger, they can't use excessive force, and you own every bullet that comes out of that gun. There was no more threat, and he kept going, and he kept going. And as Timmy fell to the ground, he kept going, and he kept going, right to the point where Timmy's body bounced off the pavement as he tried to get away. And what do we know from Dr. Weinberg? That those shots, those ones to Timmy's back as he fell away, that's what killed him. He would have survived this one. He would have survived this one. He would have survived this one. But when you watch the video, take a look at what way Timmy falls. You'll see this, and you'll see this, and you'll see him fall. All of them while he was falling. And it did happen quick. It happened quick, though, because the defendant made it happen quick. He chose that. That's his choice. He's responsible for those choices. He's responsible for going like this and tracking Timmy as he fell to the ground and continuing to shoot until he took all of the life out of him. That is not justified. Now, you didn't hear anything during closing about provocation, but you're going to see you're being asked to consider provocation manslaughter. To be clear, the defendant did not act under the influence of extreme mental or emotional disturbance, and he was not under extreme mental or emotional disturbance which caused extreme provocation. That's important. This is extreme. You're being asked to consider whether 5'7", 121-pound Timmy's single punch to the defendant, who was armed with a gun and outweighed him by over 200 pounds, caused such a reaction that it overwhelmed the defendant to the point that he could not consciously think about anything, that he couldn't understand what was going on, and it was purely a reaction without any thought, process, or any ability to react any other way. Another way to look at this is part of that instruction is going to tell you that not only would you have that, but that a reasonable person would have that. You all went through the jury selection process. You were all picked because you are reasonable, everyday people. You would have to believe that if you were in that same situation, you would have no ability to control yourself, that you would have such a rush, surge, emotion, and you'll see in the instruction, not just anger and not just hatred. This is beyond that. This is
you on this in the past, but I want to emphasize it at this point. You're not to put yourself in either Mr. Pouliot's position or Mr. DeLee's position. Your job is to review this case objectively, looking at the evidence dispassionately, so disregard the prosecutor's argument just now to put yourself in that position and guess or think about what you would have done in that position if you had been there. That's not an appropriate framework to consider the evidence in this case.
A reasonable person. So a reasonable person in that same situation would have had to been overtaken by such extreme emotion, beyond anger, beyond basic hatred, emotion that is uncontrollable. A reasonable person, not just him, but a reasonable person would have to react the same way. You heard the defendant's reaction. You heard that minute after he killed. You heard his first statements to the police. There was nothing about, I saw red, I didn't know what I was doing. There was nothing about, I don't know what happened, I was just overwhelmed. There was nothing about that, ladies and gentlemen. It was, they punched me in the face, I was defending myself, they threatened to kill me, and Manchester fucking scripts. That's what you heard. There is absolutely no evidence that the defendant was extremely provoked to the level that a reasonable person wouldn't have been able to control themselves.
Dude, these guys are awesome. Hey, get back here, back here.
That's not self-defense. That is second-degree murder, and that is reckless conduct. If you go back to that jury box, and you're wondering about reckless conduct, listen to the audio from 54 Old Granite Street. Listen to the bullets whizzing down the street as people are walking across the street. That is reckless conduct, and it is second-degree murder. You've sat in a trial where you've been able to see what happened before, during, and after a murder. And as everything played out that night, you saw people's reactions, you saw their body language and their emotions, you saw the defendant's actions and his emotions. At the beginning of the trial, Attorney Harrington told you that you would see the defendant's anger, that you would see someone looking for a fight, and you did. That you would see someone with countless other options before having to resort to shooting Timothy 8 times. And you did. And she told you what you wouldn't see. You wouldn't see from the defendant at any point any fear. No fear of Timmy, no fear of Timmy's friends, no actual fear at any time throughout the night, because there was no reason for fear. And just like Attorney Harrington said, there was no actual and there was no reasonable fear. Timmy and his friends were unarmed. The defendant towered over Timmy. You know how much bigger he was. Timmy's punch was not deadly force, and he knew it. That's why he kept trying to fight him any chance he got. That's why this continued, going back and forth. You saw the evolution of his anger, his rage, the jealousy, the bullying, the tough guy showing the little guy what was up. This was a bar fight. The defendant had a lot of choices that night. He could have walked away. He could have gone into Soho. He could have gone up the street. He could have punched him. He could have pushed him. He could have tripped him. He could have yelled out for help. He could have done a lot of things before he pulled out a gun and shot Timothy to death. He made 9 choices that night in that split second, all the way to the ground. And he is responsible for every squeeze of that trigger, every choice that he made. He chose over and over again to shoot Timothy. Those choices recklessly endangered every bystander on that street that night, every pedestrian, every person in a car.
Oh, yeah.
In those choices, shooting unarmed Timothy Pouliot until he was flat on the ground and dead,
JB,
were the choices of knowingly causing the death
Thank you
of
for the
Timothy.
gift. 5 membership each.
That's why
Thank
we're
you so
asking
much.
you to find the defendant guilty of second-degree
B12
murder
too.
and for reckless conduct.
Thank you, B12.
Thank you.
Thank you so much. Amazing. Making it rain. JPC, thank you for the 7 months. Astastic. Thank you for the 11 months. Brown chicken, brown cow. LML, love you. Love you too. Thank you. All right, so that was the prosecution. What y'all think of prosecution? All right. Well, I think that they presented a better case than, well, as far as closing, they did a better closing than the defense, but the defense gets to do a rebuttal. I guess that's how they do it in this state. I'm used to the prosecution going first, then the state, and then the whatever rebuttal. But I guess this is bizarro world, and they do it opposite. It's the opposite. By the way, we covered Jussie Smollett.
Short recess. I'll
Take
come
a
back
break.
and finish the instructions so you can start to deliberate.
So this is almost over for today. Oh, that's it? Did I do no more? This is jury instruction to get back? Oh. Wow. Is that it? Oh, they're still doing a rebuttal thing at the end?
Oh, I'm so sorry. Yes,
So Jussie Smollett loses his appeal after being convicted of staging a racist, homophobic attack on himself. Smollett was out of jail pending appeal and is now likely heading back to prison. Smollett! Say it ain't so, Smollett. Juicy. This is not enough.
Are the brothers involved in the alleged state attack?
Stage attack. Smollett. Say it ain't so, Smollett. What a travesty. Scammer. Schemer and a scammer. I don't know why. Why they did Jussie like that? You pussy. Why they did pussy like that?
Kind of discrimination, any kind of social injustice. As a matter of fact, I'm learning more about it as we're going on in the letters I've been receiving. In the testimony I've heard today, he's been doing this all his life. He doesn't just talk the talk, he's walking the walk. He's out there, he's advocating. He's involved in the community. He cares deeply about social justice issues. And for you now to sit here, convicted of hoaxing hate crimes, racial hate crimes, and homophobic hate crimes, the hypocrisy is just astounding. I don't know where to begin. I'll remember one thing that will always stick in my mind, and I've been involved in so many trials over the years, but something happened in this trial that it was remarkable, and it talks about your sensitivity to issues of social justice. You're on the witness stand. You're being cross-examined. Your liberty is at stake. It is your criminal trial. Mr. Webb is winding through some things on cross-examination, and he's going through some social media communications, and whether it was Instagram or chat or text, a little quibbling about that doesn't matter. But Mr. Webb found a line that he wanted to confront you with, and he said, "Didn't you say," and he used a word starting with the letter N, "meet me at this place at this time," and I'm paraphrasing. And rather than just answer the question, which is what a witness is supposed to do and expected to do in their criminal trial, you stopped the proceedings. You said, "Mr. Webb, out of respect for all the African American people in this courtroom, you should not be using that word." And I was amazed. But it showed, and I'm not talking about the parrying and the gamesmanship that may go on between a prosecutor and a witness on the stand. That's not why I'm telling this, recalling this event. But what I'm talking about is how sensitive you were to any kind of slight, that anybody, if the wrong words come out of somebody else's mouth, you're going to get up and speak up and complain about it and make sure that they know that they're not behaving the way you're supposed to behave.
Anyway.
The damage you've done to the city of Chicago, I've heard. It's been talked about. I'm mindful of the city's request for restitution, and if I'm going to fashion that, consider that request, I have to fashion the sentence accordingly. And above all,
Me, you
the capper
nugget.
of all cappers, your performance on the witness stand. This could only be described as pure perjury. You got on the witness stand. You didn't have to. You did. You certainly have a right to. But you committed hour upon hour upon hour of pure perjury. And I find all those to be ample factors. If this court were to decide that the things you did, that any kind of probationary sentence would deprecate the seriousness of the offense and you need to go to the penitentiary, the record is clear and it would support it. But I'm looking at everything in its totality.
Oh, God.
And I agree. It's total of social justice issues that are fighting, seriously fighting, not playing around, not doing games like you were, which would have to be filed in writing within 30 days. Anything not stated in those filings are waived for purposes of appeal. If you cannot afford lawyers or transcripts, they would be provided free of charge. Do you have any questions?
No, I would just like to say to Your Honor that I am not suicidal. That's what I would like to say.
Okay.
I am not suicidal.
Okay.
I am not suicidal. I am innocent, and I am not suicidal. If I did this, then it means that I stuck my fist in the fears of Black Americans in this country for over 400 years and the fears of the LGBTQ community. Your Honor, I respect you and I respect the jury, but I did not do this, and I am not suicidal. And if anything happens to me when I go in there, I did not do it to myself, and you must all know that. I respect you, Your Honor. I respect your decision. Jail time. I am not suicidal.
Okay. Mr. Uche, let me inquire, are there any post-sentencing motions you care to present right now?
Yes, Judge.
Yes, Ms. Widow.
The defense would wish to present a motion to reconsider sentence.
Right.
Yes.
File it in Stanter.
Wait, no.
It is timely filed.
No.
And let me say, I've obviously considered the sentence at great length. And it's timely filed, so it's preserved for purposes of appeal. Motion to reconsider sentence is respectfully denied.
He needs more time.
And is there another, one second, Randy. Anything else? Just a second. Is there going to be a notice of appeal filed?
Yes, Judge. We're filing a notice of appeal. We're going to be emailing to the court right now. Judge,
Okay. All right. Notice of appeal may be filed to work out probation, the restitution, that's statutory. But we need
To appeal, we would ask that you suspend the jail sentence in light of the incident of filing of the notice of appeal.
Did I do what?
Suspend the jail sentence in light of the notice of filing of appeal.
That will be respectfully denied. Yes, Mark. Mr. Lewis.
Well, they're desperate. They're desperate to get this liar and scammer, kind of a piece of shit, if you ask me. And especially in that time where all this racial stuff was over the top and crazy. There's people like this that take advantage. What did Hillary Clinton say? Or what's it, Hillary? It said, never let a, I don't know, what is it? Never let a thing go to waste. Never let a disaster or tragedy go to waste or some shit. I don't know. Yeah, these people riled up. And there's people still to this day that believe him. They believe him. They still, no, we stand with Jussie. We stand with Jussie. No, we're going to ride with him.
In light of our notice of appeal.
No.
No.
I'm not saying, no.
I said no.
The wheels of justice turn slowly, and sometimes the hammer of justice has to fall, and it's falling right here, right now. I'm not saying this. This happens right here, right now.
Probably a lot of you that never saw this, but we were covering this back then. It was something. I didn't cover this in depth, but we were watching this, like, I guess the sentencing or the trial or whatever it was.
Okay. Charlotte.
So the new news is that his appeal got denied. That's what the new news is. So we're just looking back at the sentencing.
Yeah, you can tell. Look at his demeanor. That guy's so egotistical.
Yeah,
I never understood people that are liars like this, that like have to continue to perpetuate that lie. Like they can't own up to the shit. Like you just have to keep it going and going and going and going and going.
I'll give you those details. Okay. All right. Any other matters to come before the court today? All right. Defendants remanded to the custody of sheriff.
Watch this too.
Yo, did you see like his sass and shit? Look at him. What did he sing? How can I hear that shit? Bro. Hold on, man.
212150. That's 5 months and 10 days of jail that Jussie Smollett's going to do because he lied about the hate crime that happened.
What I don't get is
in Chicago whenever he.
Yeah, he's going back to jail. They said, but I thought just gave him 5 months.
What are
right?
you screaming? This is crazy, bruh. Bruh, what was he screaming?
Somebody said probably Black Power.
Was he saying BLM? Black Lives Matter. What a fiasco! I want to see if I can find. There we go.
I assure you, this court does not.
Hold on a second.
An hour, years on this case.
Okay, let's see.
Yeah, I'll talk to you about it. I'll give you his details. Okay.
I don't know if we'll hear it.
I think I did end up finding the audio. Here it is.
Oh, they cut it off.
I am not suicidal. I am not suicidal, and I am innocent. I could have
Act like you're that important, like people trying to get rid of you and shit.
said that I was guilty a long time ago.
Well, he's saying he's still innocent, yo. Still.
Ride or die.
Oh my God, dude. I'm gonna have to clip that. Jussie, your content, man. I'm gonna have to clip that for Facebook.
Juicy.
Bro, talk about a climax, right? Like, that's how it should be done. Wow. Was that kind of weird to say? I don't know if that was weird. Oh, I can't. It's animated. What's that?
They did a press conference after.
Or you can check us out on this.
That. So the 5 months is really, according to this lawyer, going to be 2.5 months.
Oh. Yeah, so I'm a little confused because they didn't give him a whole bunch of time though. Let me see what's going on in the news. An appeals court Friday upheld the disorderly conduct convictions of Jussie Smollett, who was accused of staging a racist homophobic attack on himself. Juicy. The conviction was upheld. Just move on with your life, man. Or so they just made conviction appeal lost. Move on, man. Let it go. It's over. Well, the thing with him, maybe why he can't let go, because maybe I don't know if his career is messed up because of this now. Jussie Smollett. 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 Smollett.
Welcome back to True Crime on Unfiltered. Well,
True crime.
Kind of, sort of true crime. We all know Jussie Smollett's MAGA country hate crime was all a big, enormous hoax, but now the two brothers who helped him pull it off are showing us how it all went down.
Oh, the twins.
Country. And he said, "What did you say to me?" And then that's when I threw the first punch at him. I held the blow because I didn't want to hurt him, of course. So I made it look real, but I held it.
But the police realized pretty quickly this wasn't quite adding up. The former Chicago police superintendent is one of many people featured in the new Fox Nation docuseries, Jussie Smollett, The Anatomy of a Hoax. Eddie Johnson joins me now. Sir, thanks a lot for your time. Really appreciate it. So you were one of the first people to see this so-called evidence in this case. You know, being the cop you are with a lot of street smarts.
I mean, Juicy wrote a check. He wrote a damn check to these guys to pay them for the scam. Like, who writes a check? No, Juicy.
What specifically raised the red flag that something's not right here?
No, Juicy.
Well, first of all, thanks for having me, Dan. But there were a few things. The first thing that jumped out was the fact that Mr. Smollett was bundled up because it was one of the
But they're also saying he's going to go to jail, though. That's the thing. The conviction for lying to police about a hate hoax crime upheld in Illinois appellate court. He'll be going to jail. Oh.
Oldest nights of the year at that point. I think it was like 15 below zero. And so he was bundled up, in the intersection where they yelled at him is a very large intersection. So the chances of two MAGA white guys being able to know in that intersection that was the gay guy from Empire, that just struck us all as quite odd. And then
And they say he was going to get like a Subway sandwich like at 3 a.m. or something like that. I don't even know if Subway was open 3 or 4 a.m.
And the fact that they were shouting these homophobic slurs and referred to him as that Empire guy, you know, the chances of all that coming together like that at 2 o'clock in the morning was it just didn't sit right. But then the other thing, when I saw the video of the two guys walking, one of the first things that I said looking at that video, I said, these guys are walking like two black guys, not two white guys. But, you know, who knows? Who knows? Yes. But that was my instinct.
Sir, here's what the Osindaro brothers said. They were talking about some of your comments. Take a listen. I want you to react afterwards. Listen to this.
You know, Eddie Johnson said he could tell in the footage that you guys were black, right?
Really? I feel like he's just saying that.
Hindsight is 20/20.
Yeah,
Cap.
come on.
I called Cap on that. I called Cap on that.
We was in character the whole time.
In character, what they walking like?
That you may have about what you think the law ought to
Oh, wait, hold on.
Now, under the constitutions of both the United States and New Hampshire's own constitutions, all defendants have an absolute right not to take the witness stand to testify. So the fact that Mr. DeLee has not testified in this case cannot be considered by you in any manner or in any way in deciding the outcome of the case.
I think that's a big thing. I would normally say, they shouldn't
the state
testify.
that has the burden of proving guilt beyond a reasonable doubt, and the defendant has no obligation to present any evidence or to prove that he's innocent because he is presumed to be innocent.
And Abby didn't testify. And what about
the laws of the state of New Hampshire?
What about John's friends? They didn't testify either.
Set forth certain crimes, and those crimes each have a precise definition. And the definition of a crime is framed in terms of certain elements that the state has to prove beyond a reasonable doubt. So the state doesn't have to prove each and every fact in a case beyond a reasonable doubt. Rather, it has to prove each element of the definition of a crime beyond a reasonable doubt. And in a moment, I'll explain to you more precisely what the elements are of the crimes charged in this case. But in general terms, all crimes have at least two elements, intent and an act. So in order to determine if a person has committed a crime, it's absolutely necessary for you to know both what the person's actions were and what his intentions were. So unless the person has both acted to do something that's criminal and has acted with the required mental state at the time those acts occurred, the person has not committed a crime. So those two things have to coincide at the same time in order for the defendant to be guilty of a crime. And so in deciding it's important, moreover, to keep in mind that the definition of the level of intent required by the definition of a crime I'm going to define that for you more precisely here, but pay attention to the definition of the level of intent because sometimes the law treats the same physical act differently depending on what a person's mental intent was at the time that act occurred. So let me give you an example. Let's assume you have two cases. In the first case, the evidence is the defendant gets behind the wheel of a car, drives the car, strikes a pedestrian, causes serious physical injury to the pedestrian. And in that first case, the evidence is that the defendant has the specific intent, purposely wants to run over and hurt that person, and does so. Second case is the defendant gets behind the wheel of a car, drives the car, strikes a pedestrian, causes serious physical injury to the pedestrian. But in the second case, the allegation is that the defendant was negligent or reckless, like doing something, not paying attention, or consciously disregarding some serious risk of harm. So the physical acts in both cases are exactly the same. Defendant got behind the wheel of a car, drove the car, struck the pedestrian, caused serious physical injury to the pedestrian. But the defendant is guilty of very different crimes depending on what his mental intent was when those physical acts occurred. So that's why it's important to pay attention to the definition of the level of intent required by the definition of a crime. And whether a defendant acted with the required intent is a question of fact for you to decide. Keep in mind, there's often no direct evidence of a person's intent because there is no way to examine the inner operations of a person's mind. So you should consider all the facts and circumstances and evidence in deciding whether the state has proven that the defendant acted with the required intent. So in this case, the defendant's charged with 2 counts of second-degree murder and with reckless conduct with a deadly weapon. So the two charges of second-degree murder are what we call alternative theories based on the same underlying conduct. So the law provides that crimes can be committed in different ways, and the law allows the state to present alternative theories to a jury. So if you find that the defendant's guilty of both versions of the crime based on the same underlying conduct, the defendant would only be sentenced on one of those convictions. And the crime of reckless conduct with a deadly weapon is a separate charge, an independent charge from those other two. So each of the charges against the defendant does constitute a separate offense, which you have to deliberate on and determine if the state has proven the defendant's guilt beyond a reasonable doubt. So the fact that you may find the defendant guilty or not guilty of any one of the charges should not influence your verdict with respect to the other charges. As I said, the defendant's been charged with the crime of second-degree murder, and the first version of that is knowing second-degree murder. The definition of knowing second-degree murder has three elements, and the state must prove each element of that definition beyond a reasonable doubt. So for this crime, the state has to prove the following. Number one, the defendant caused the death of Timothy Pouliot. Number two, the defendant acted knowingly with respect to causing the death. And number three, the defendant's conduct was not justified on the basis of self-defense. So a person acts knowingly when he's aware of the nature of his conduct or the circumstances under which he acted. To prove the defendant acted knowingly, the state does not have to prove the defendant specifically desired or intended a particular result. What the state must prove is the defendant was aware of the nature of his conduct or the circumstances under which he engaged in the conduct. The defendant has been also charged with the crime of reckless second-degree murder, and the definition of that crime has four elements, each of which the state must prove beyond a reasonable doubt. So for this crime, the state has to prove the following. Number one, the defendant caused the death of Timothy Pouliot. Number two, the defendant acted recklessly with respect to causing the death. Number three, the defendant acted with extreme indifference to the value of human life. And number four, the defendant's conduct was not justified on the basis of self-defense. So part of the definition of the crime of reckless second-degree murder is that the defendant acted recklessly. And to prove that the defendant acted recklessly, the state must prove the following. First, that the defendant was aware of a substantial and unjustifiable risk. This means there must be proof that the defendant knew that there was a substantial risk that his conduct would cause a particular result. Second, if the defendant was aware of the risk, there must be proof that he consciously disregarded the risk. In other words, the defendant decided to disregard the risk and took a chance that his conduct would cause a particular result. Third, you have to examine the circumstances known to the defendant. From what he knew of the circumstances, you must decide whether his disregard of the risk was a gross deviation from what a law-abiding person would have done. So here the key words are gross deviation. If you find that the defendant's actions were unreasonable or thoughtless, that is not enough. To find the defendant acted recklessly, you must find that his disregard of the risk was a substantial departure from what a law-abiding person would have done under the same circumstances. It's not enough for the state to prove that the defendant acted negligently. That is, it's not enough to prove the defendant failed to become aware of the risk involved. The state must prove the defendant was aware of the risk and consciously disregarded it. Now, the crime of reckless second-degree murder requires the state to prove more than that the defendant acted recklessly, as I've just defined that term for you. For the crime of reckless second-degree murder, the state must also prove that the defendant's conduct occurred under circumstances manifesting an extreme indifference to the value of human life. This means the circumstances must show a blatant disregard for the risk of human life. So if you find that the state has proven beyond a reasonable doubt that the defendant all of the elements of either version of second-degree murder, then the charge may be reduced to provocation manslaughter if the murder was the product of provocation. So, like self-defense, the state has the burden to prove beyond a reasonable doubt that the murder should not be reduced to provocation. So the state has to prove two elements with respect to this. The state must prove, number one, that the defendant did not act under the influence of extreme mental or emotional disturbance. extreme mental or emotional disturbance means acting with sudden passion, greater than anger or resentment, which so dominates and clouds the thinking that reason and normal control are lost, resulting in a killing. It does not mean merely a subtle hatred. It means being virtually swept away by passion and not in full control of oneself. It means that there was no cooling off, that is, no thought about and consideration of a course of action. And number two, that the extreme mental or emotional disturbance was caused by extreme provocation. The law which distinguishes provocation, which will mitigate an offense from murder to manslaughter, cannot be clearly defined. So reasonableness is the test. A murder is manslaughter only if there is provocation, which would cause a reasonable person to kill another out of passion. The law requires that the provocation must be so great as to reasonably excite the passion and heat of blood. Passion without adequate provocation is not enough. There must be provocation to the extreme so that the defendant, in the anger of the moment, kills another person. Mere words are not enough for extreme provocation. Also, a lawful act, even if it involves physical force, is not recognized by the law as sufficient provocation. So if you find that the state has not proven beyond a reasonable doubt all of the versions of second-degree murder, then you must go on to determine whether the state has proven whether the defendant is guilty of a similar but less serious crime of reckless manslaughter. So reckless manslaughter has three elements, each of which the state must prove beyond a reasonable doubt. So for this offense, the state must prove the following. Number one, the defendant caused the death of Timothy Pouliot. Number two, the defendant acted recklessly, as I've previously defined that term for you, with respect to causing that death. And number three, the defendant's conduct was not justified on the basis of self-defense. So the difference between reckless second-degree murder and reckless manslaughter is that for you to find that the defendant committed reckless manslaughter, the state does not have to prove that the defendant was acting with extreme indifference to the value of human life. As I mentioned, the defendant is also charged with the crime of reckless conduct with a deadly weapon. So this crime has four elements, each of which the state must prove beyond a reasonable doubt. So for this crime, the state has to prove the following. Number one, the defendant engaged in conduct that either placed or may have placed another in danger of serious bodily injury. And number two, the defendant acted recklessly, as I've defined that term for you. And number three, the defendant used a deadly weapon. And number four, the defendant's conduct was not justified on the basis of self-defense. So the state alleges that the defendant used a handgun as a deadly weapon. A handgun is not automatically a deadly weapon. Rather, the term deadly weapon means any object which in the manner it is used, intended to be used, or threatened to be used is known to be capable of producing death or serious bodily injury. And the term serious bodily injury means any harm to the body which causes severe, permanent, or protracted loss of, or impairment to, the health or function of any part of the body. So in this case, the defendant has asserted that his conduct was justified based on self-defense. So when there's some evidence of this defense, the state must prove beyond a reasonable doubt that the defendant's conduct was not justified based on self-defense. In other words, if you have a reasonable doubt as to whether the defendant's conduct was justified based on self-defense, then you must find the defendant not guilty. On the other hand, if you find that the state has proven beyond a reasonable doubt that the defendant committed all of the elements of a crime charged, including that his conduct was not justified based on self-defense, then you should find the defendant guilty. So the law distinguishes between the use of deadly force and non-deadly force. So the term non-deadly force means any assault which does not constitute deadly force. And the term deadly force means any assault which the actor commits with the purpose of causing or which he knows to create a substantial risk of causing death or serious bodily injury. So except in situations that are not relevant to this case, all persons have a constitutional right to keep and bear arms. So whether a person is lawfully entitled to use a weapon for self-defense is a question of fact for you to decide. With respect to the defensive use of a firearm, the following considerations apply. Number one, purposely firing a firearm capable of causing serious bodily injury or death in the direction of another person or at a vehicle in which another is believed to be constitutes the use of deadly force. Number two, if the defendant merely produces or displays a weapon, the defendant has used non-deadly force. If you find that the defendant responded to a threat which would be considered by a reasonable person as likely to cause serious bodily injury or death to the defendant or another by displaying a firearm or other means of self-defense with the intent to warn away the person making the threat, then the defendant has not committed a criminal act and you must find him not guilty. If the defendant's use of a firearm falls somewhere between numbers 1, 2, and 3, or is not otherwise covered by the definitions of 1, 2, and 3, as I've just explained those concepts to you, then it's up to you, the jury, to decide whether the use of the firearm constituted deadly force or non-deadly force based on the facts and circumstances of the case as you find them to be. So the defendant has a right to use deadly force on another person to defend himself if, number one, the defendant actually believed the assailant was about to use deadly force against the defendant. In other words, the defendant could use deadly force if he actually believed he was in imminent danger of death or serious bodily injury by an assailant. Number two, even if the defendant actually believed that such danger existed, his belief must be reasonable. In other words, there must be reasonable grounds for the defendant to believe that the assailant was about to use deadly force against him. Self-defense does not require an actual danger to the defendant. Rather, the defendant must reasonably believe that the assailant was about to use deadly force. For self-defense to be justified, the defendant must have a reasonable belief that the danger presented is imminent and in the present. That is, the defendant must reasonably believe that the assailant's use of force is immediately forthcoming. The defendant must reasonably believe that the amount of force he used was necessary for self-defense. A person is not permitted to use excessive force in self-defense, only a reasonable amount of force. The defendant can use the amount of force which he reasonably believed was necessary under the circumstances, so long as, at the time, there were reasonable grounds for that belief. The defendant is only allowed to use deadly force to defend himself if he actually believed the other person was about to use deadly force against him, and that belief is reasonable, as I've explained those concepts to you. The defendant is allowed to use non-deadly force to defend himself if he actually believed another person was about to use non-deadly force against him, and again, that belief was reasonable. In other words, a person is not allowed to use deadly force to protect himself from non-deadly force. Self-defense is not justified if the defendant knew that he could retreat from the encounter with complete safety. However, the defendant was not required to retreat if he was in any place he has a right to be, and if he was not the one who started the encounter. In deciding whether the defendant was justified in his use of force, you should consider all of the circumstances surrounding the incident. You should consider how the defendant acted under the circumstances as they were presented to him at the time, and not necessarily as they appear upon detached reflection. So you should consider whether the defendant had a reasonable belief that he was justified in using force when he acted in the heat of the moment. A past danger will not support a finding that the defendant was justified in using force upon another person. Self-defense does not permit acts done for purposes of retaliation, revenge, or redress. Sorry, I just saw a typo. All right, so members of the jury, the principles of law that I've given you are intended to guide you in reaching a fair and just result in this case, which is important to both the parties and to the court. So you're to exercise your judgment and your common sense, as I've said before, without passion, without prejudice, and without sympathy, but with honesty, understanding, and due deliberation. And so when you've considered and weighed all the evidence in this case, you must make one of the following findings with respect to each of the charges that are before you. You must decide if the state has proven each element of a charge beyond a reasonable doubt. If you have a reasonable doubt, in other words, if you have a reasonable doubt as to whether the state has proven any one or more elements of the offense charged, then you must find the defendant not guilty. If you find that the state has proven all of the elements of a charge beyond a reasonable doubt, then you should find the defendant guilty. Okay, so let me explain how this is going to work with the second-degree murder just in terms of deliberation. So with respect to the charge of reckless conduct with a deadly weapon, if you find that the state has proven, if you find that the state has not proven all the elements of that charge beyond a reasonable doubt, of course you have to find the defendant not guilty. If you find that the state has proven all of the elements of the charge of reckless conduct with a deadly weapon beyond a reasonable doubt, you should find the defendant guilty with respect to that charge. With the respect to the charges of second-degree murder, the process of deliberation is as follows. If you find that the state has proven all of the elements of second-degree murder beyond a reasonable doubt, then you must go on to determine if the murder should be reduced to manslaughter, as I've explained that to you. In other words, the state must disprove beyond a reasonable doubt that the murder was the product of extreme provocation, as I've defined those concepts for you. If you find that the state has not met its burden with respect to that question, you should find the defendant guilty of provocation manslaughter, but not guilty of the second-degree murder. On the other hand, if you find that the state has proven that the charge should not be reduced to provocation manslaughter, then you should find the defendant guilty of second-degree murder. And I'll remind you, that concept reasonable doubt is just what the words would ordinarily imply. The use of the word reasonable means the doubt must be reasonable rather than unreasonable. It's a doubt based on reason. It's not a frivolous or a fanciful doubt or one that's easily explained away. Rather, it's such a doubt based on reason as remains after consideration of all of the evidence the state has offered against it. So your verdicts in this case have to represent the considered judgment of each juror. So in order to return a verdict, it's necessary that each and every juror agree with that verdict. In other words, you have to be unanimous. So when you've arrived at a unanimous verdict on each of the charges, let the bailiff know, and then you'll be brought back here to the courtroom where the foreperson will deliver those verdicts in response to questions that the clerk of court will ask of you. It's the foreperson's job to see to it that the jury takes up the issues that are before you. So he or she should see to it that each juror has a full, fair, and adequate opportunity to explain his or her views with respect to both the law and the evidence. And as your first order of business, I'll have you choose from amongst yourselves whom you want to serve as the foreperson. And then once you've selected the foreperson, just let the bailiff know so we know who that person is. All right, as I said, the case is important to both the parties, and in your deliberations, you must follow the instructions which I've given you and make a conscientious effort to determine what a fair and just result is, because that is your highest duty as officers of this court. It's also your duty as jurors to consult with one another and to deliberate with a view towards reaching an agreement, if you can do so without violence to your individual judgment. So each of you have to decide the case for yourselves, but do so only after impartial consideration of the evidence with your fellow jurors. So in the course of your deliberations, don't hesitate to change your mind or re-examine your position if you're convinced that you were initially wrong. But don't give up your honest conviction as to the weight or the effect of the evidence simply because of the opinion of your fellow jurors or solely for the purpose of returning a unanimous verdict. Now, if you have any questions about the law that applies during your deliberations, have the foreperson write that question out on a piece of paper, put the date and time on it, notify the bailiff, and I will get you an answer most likely in writing as quickly as I can. If you have any questions, though, about the facts or the evidence in the case, I can't help you with that. As I've told you before, you and you alone decide the facts based on the evidence presented. You'll have the exhibits we'll introduce that'll go back with you into deliberation, and you'll have to rely on your collective memory about the testimony of the witnesses. And so there are 3 alternates. So jurors number 7, 12, and 13. So 1, 2, 3, 4, 5, 6, 7. I think you're 7, and then 12 and 13. So the three of you are alternates. So I can't excuse you yet because it does happen even at this point that a juror becomes sick, has a family emergency, or something happens, and one or more of you might be brought into the deliberation process. So it's essential you continue to abide by my instructions not to talk about the case with anyone else, but also not to talk about the case with each other, because it does happen. As I said, one or more of you might be brought into the process, and you need to come at it without those outside influences. And so the remaining 12 of you can retire to deliberate. We'll get you the exhibits, and I just caught a typo I need to correct, and I'll get the instructions back to you as well quickly.
All rise, please.
So does this count? Should I start the timer now? Or wait till they pick a 4-person? Yeah, just start it now, I guess. I feel like the judge is trying to run the clock to the end of the day.
We didn't talk about maybe sending the TVs back for the jurors.
It's fine. Do you have a clean laptop to send?
Yes, both parties have checked it.
Okay. Yeah, that's fine.
All right. Thank you.
And Your Honor, also,
yes.
The exhibit list that we had just prepared without the IDs, we were asking, I think, joint
Correct.
of that.
Yes, and you're okay with the, I mean, my only concern was whether there was agreement about the descriptions. Candidly, I didn't read through the description, so I just want to make sure there was nothing that either side had any objection to, but that's fine with this number of exhibits to send them. Okay, as long as you're okay with that, then that'll go back with them as well. Okay, thank you.
All rise.
On a boat, come on the train. So the poll is, for those that have a working poll, murder, manslaughter, or not guilty / self-defense. And the polls are actually kind of close. 47% say murder, 44% say manslaughter, 10% say self-defense. Put in your votes. Put in your votes. So I wonder how long they'll let them run today. I don't know. They're gonna let them run late. They've been ending like at 4 o'clock. Also, yeah, how long is it gonna take for a verdict? I don't think it should take long. Or will it? Murder, manslaughter, not guilty. I do think they're going to find him guilty of the lesser charges, at least the reckless endangering of other people, maybe. I'm mixed on the whole murder / manslaughter. I'm not sure. I'm kind of leaning a little bit towards manslaughter. What the jury's going to find. Ooh, it switched to manslaughter. 47% say manslaughter, 43% say murder, 10% say not guilty, self-defense. Murder, she wrote. Johnny boy. Johnny boy. Johnny boy. JD says they'll wait until after dinner. Nobody wants to cook. Hey, it could be done today, man. I wonder if they'll do sentencing, though. Maybe they'll wait till the morning for sentencing if they come back with a verdict today.
34.
Johnny,
34. 35. 36.
On with the counting.
37. 38. 39. 40. 41. 42.
Yeah, those instructions are, I don't know. It lost me. And the first one, it lost me.
43s, 42F. 43A. B.
Maybe they're doing the exhibits.
C.
Johnny boy. All right, I'm gonna warm up some food for the baby. I'm gonna let it run. Man, Juicy going back to jail. Damn. Apparently he only did 6 days in jail, so I guess he has to go make up the time now.
Oh, I get confused because I saw 54. That's why I
44.
Oh, tomorrow's Saturday. Yeah, I don't know what I'm thinking. So I guess Monday.
46. 47. 48. 49.
In New Hampshire, murder is life, no parole. Damn. Manslaughter up to 30 years. Oh.
52. 53. 54.
All right, I'll be back.
55.
Johnny.
57. 58.
I know, it's just.
59. 60. 61. 62. 63. 60. That was a question on 4. 65. 66. 67.
68 if it's right.
Oh, yeah. 68.
Good job.
69, 70, 71, 72 is ID.
Yep.
72 is ID. 73, 74. 75 is for identification.
Yes, that's all.
Thank you.
Thank you, and I'm sorry I twisted the. It's less. It has an HDMI.
Yeah. Wait, so that hit an HDMI, right? No, it doesn't have an HDMI.
Yeah, the judge said.
Oh,
The judge said one of the TVs pulled that.
Yes, yes. We're gonna send the speaker and the TV.
Okay.
It's empty there, so it's just do empty recycles in.
Bring that in the jury room.
But when you move this back, this piece, if you go that way, we'll try to slide on. There's another thing. I gotta give you a piece. Rachel, you need.
There's a longer one over there. It's not a very big deal.
And you said you wanted to send back the speakers?
Just one. No,
Okay.
we didn't instruct them not to use the internet or computer, but they were generally instructed that, right?
door, do not enter.
He didn't say anything about you not using the internet on the computer, did he? Do we need to know?
Nancy, we're just talking to the defense. Because they're going to have a laptop, does the judge normally send any instructions for them not to try to access Wi-Fi or anything?
That's what he meant by clean laptop.
Yeah, it is clean.
Yeah, but I mean, they can always theoretically, figure out how to turn it on if they try.
It's clean as in there's nothing on it, it's not connected to the internet right now, but they could obviously try to connect through the court's Wi-Fi or something like that.
I'll ask him.
Are we ready?
I don't know what the normal. This is the one we normally send out.
He was pretty clear about shouldn't do that at all.
Yes, no, absolutely.
You would like to think.
Then did you get to speak?
Yeah.
Somebody, okay, all right. Thank
Finish
you.
and do nice.
Quick question for you.
Yes.
Some of the media outlets are doing you as Ben and some of the
I go by both.
Okay, I just when I put out the final photos.
The one, the ones, and again, it also doesn't actually bother me. My name is actually F-A-L-K-N-E-R, and I'll constantly F-A-U-L-K-N-E-R. Doesn't really matter, but if you want it accurate,
Yeah, no, I looked your name up properly, but Ben and Bender, I'm Jeff and Jeffrey, so it's like usually when I'm in the office, I'm Jeffrey.
right, yeah, exactly. Yeah. No, I go by either, it doesn't matter.
Okay. Just didn't want you to be offended. No, I want probably the least of the worries.
Yeah, that's, out of all the things to worry about, it's not that.
I don't even know what I'm doing yet, Marty.
It's never had that come up or done an instruction and said as long as it's not connected to the internet. I don't know, like if you have administrative controls, make sure that it's the Wi-Fi is not, like you can't turn on Wi-Fi unless you're.
I don't even know if there's a way to do that.
Oh, yeah. I mean, technically, I suppose we should tell them they should also remove the motherboard or.
Right, yeah.
Pop off the keys and move them around, like.
No, I think it's okay.
Yeah.
If
I think we've been told pretty clearly not to.
If they're getting on the internet with that computer, then they're disregarding a whole bunch of other
stuff.
Right?
And I hope that one of the 12 would be like, hey, I don't think we should do that.
Hey guys, maybe we should ask them.
I mean, they want to watch cartoons or something.
Right.
I just laugh every time. It's like we just wrap up a murder trial and here we are doing like this, and every time we go to like a party or something, they're like doctors and lawyers, and I'm like, yes.
So the last murder trial I had, there had to have been 270 exhibits, and you wouldn't believe, the jury goes out at like, I don't know, 3:30 or something, and the lawyers are in the courtroom, and they're not so involved. And the court, the clerk is not involved at all, so just like go have at it. And we're counting through, and you got the physical bullets, and then you got the papers, and then you got these like little tiny scraps of paper that have become exhibits. I mean, it was like, we can't find 216, It was horrible.
So this was nice. Yeah, this was not. This wasn't that. Yeah, this is our first case again. Yeah. See, I'm sure we will see. I prefer to shake before verdicts. Yeah, that's a good, yeah, great. Shake, always shake before verdicts. Because otherwise, we'll seem condescending for one person. Right, well, yeah, that's fair enough. No, beginning to end. All the way back to January now.
Yeah.
It's pretty quick turnaround.
Yeah.
Yeah. Yeah. I felt it. Well, I think in these cases, being able to do it so quickly and everything was just so simple to put. Oh, there's that much evidence. That's that much. And you know, it's good for a criminal case, okay? But I don't know that it's good for every moment of everybody's life to be recorded like that. It's creepy. It's creepy, especially with the audio everywhere. Yeah.
I feel bad for people who are just being embarrassing dancing on the dance floor that we just like broadcasting on the web.
Yeah.
Can you imagine if you saw yourself in there?
Every time I see it, I laugh.
Obviously,
The weird dancing? Yeah.
I couldn't stop laughing. I watched it.
I know you did. I was like, oh, best day ever. And it really broke my heart. It was very disappointing.
Anybody else?
You didn't really think we were going to go through with it. We're going to do it if we had to. Yeah. I didn't until and then all yours.
I think
And
it is.
then,
Well,
I mean,
that's me.
Sorry. The microphone. I don't know.
Yeah, other than the microphones, I think we've got.
Yes.
This is this whole panel and everything. touches
Literally all of
ours,
it is ours.
right?
All these are.
Okay.
I'm gonna go get the
Do you wanna
boxes
get
so we can
the-
start. No other cases coming in here.
Yeah, just pulling
Okay.
cards. I
Out
feel
of the
like.
way.
Break it down. I can
Not
do
this
it.
afternoon, no. Check all this, they're gonna take TVs and things before.
They're taking the TVs
Yeah, that's it. So Monday, we're gonna have, just a regular list here.
Just keep bringing out your rate now.
I think he'll probably tell you.
For the. Does he bring them in the court?
Yeah. Yeah, I think it all gets, because this goes back and forth.
Assuming it's banks.
Just letting there's still streaming our audio. They're still streaming the audio across the web.
Oh, well, that's gonna start immediately.
Yeah. So,
Who's doing
the second one, just that.
Okay, so. This is
I mean, we're supposed to be making one, so.
Hey Nancy, are we in courtroom one on Monday?
Yes.
Now he's doing the cleanup work?
No, actually,
Now, it's.
Please be seated. Once you're comfortable in the chair, I'm going to ask that you speak a little bit loudly or close to the microphone. And if you could tell us your first and last name, and please spell your last name for my court reporter.
Daniel De Jesus, Dejesus.
Your witness.
Thank you, Your Honor. Mr. De Jesus, what is it that you do for work?
I'm a firefighter for the Aurora Fire Department.
And how long have you been with Aurora Fire?
8 years now.
What is your current role with Aurora Fire?
I'm a fire medic.
And in 2019, what was your title?
I was a basic EMT firefighter.
So in 2019, at that point, you had been with Aurora Fire for about 3 years. Is that correct?
Yes, ma'am.
Prior to being,
Biscuits. Somebody said law and crime said they left. Oh, let me pause this, I guess. Let me pause the timer. I was laying down. Laying down, go to sleep, hold your breath. Pause. Okay. Said a biscuit. What's about it? There's a biscuit. Let me see if I can find on the world of Twitter. Is there anything about this? On crime. Nothing from Kathy. Let me just type in this guy's name. John DeLee.
Functions.
I don't see nothing about it. Yeah, that's weird because, like, I don't know. How do we know? Are they coming back Monday? What time?
Jury instructions.
Day 4 has ended. Weird. I guess we'll have to wait till Monday. I don't know. All right. Well, I guess if I see anything, I guess I'll come back on Monday at 10 a.m. I guess like they've been doing every day. Everything I can think of, and we'll see what happens. No, I don't see Law and Crime said anything, and they ended the stream. Law and Crime, why'd you do that? Nada. Did you hear the hot mic? Yeah, I did. I mean, it was a different. Started playing a different video or something. There was a hot mic moment. I was playing it on my phone. I didn't hear anything besides what just happened now. All right, I guess we'll call it for now. I'll keep you guys posted though if I hear something. I mean, I guess what I'll just do is I'll over the weekend or something. I'll set the day from Monday 10 a.m. I mean, if something just happens to pop up, of course I'll jump back on. And I guess that's it. And hopefully we get a chase tonight. Still very early. Anything could happen. A chase, a standoff, a manhunt. About 5 minutes of casual talk.
Jury instructions.
That's nothing. All right. Guess I'll get off then, man. Sorry it ended off like that with nothing really. I don't know. We just kind of left to our own devices to figure things out. But yeah, I'll jump on if there's any kind of anything, chase, whatever, and I'll keep you posted for the verdict, which I'm guessing is gonna be Monday.